although I think it ought to have been mighty clear that I had big problems with this statute. I made no bones about that from the beginning. And then count 6 is dismissed.
Boy, Judge Schroeder really pissed off a lot of people when he dropped count 6 against Kyle Rittenhouse. If you remember, that was the gun charge. Neither Binger nor Krause was able to produce the evidence to show that Kyle was in violation of statute 948.60, so the judge had to drop it. And this all had to do with the interpretation of the provisions of 948.60, and Democratic lawmakers are saying that it does not represent the will of the people or the will of the legislature. So they immediately set out to draft a new law that would show the world that Kyle's defense team had it wrong all the time.
Now some lawmakers argue that the law needs to be updated and written with more clear intent.
This was necessary for a purpose. However, the way and the loophole in which, Rittenhouse is not able to be held responsible, it doesn't serve the purpose of what the law was meant to do. We need to make sure that the letter of the law is clear.
However, not everyone agrees. In a statement issued by Republican State Senator Van Wangard, he said, quote, "I was surprised that this charge was even brought in the Rittenhouse case. It's been law for 30 years without anyone having a problem with it, any incidents, and without outrage, and it doesn't need to be changed now."
So a bunch of Democrats drafted a new law. They said, we're going to close that loophole. We're going to show what the law was meant to say all along. Well, whatever came of that bill? Well, we're going to go over that today. Hello out there. I am trying to get through.
With his powerful brainwaves cradled in the warmth of reasoning, it's time for Johnny Walker Dredd to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnny Walker Dredd Show.
As you know, count 6 against Kyle Rittenhouse centered on 948.60, specifically paragraph 2A. Everyone claims that this statute is completely confusing. So what I've tried to do is simplify it as much as I can here. The preamble is not a problem. It says, Wisconsin law forbids those younger than 18 from possessing long rifles if, and the provisions that follow caused a lot of commotion. Originally, Mark Richards interpreted 948.60 as having 3 provisions. So if we read this statute, it says, Wisconsin law forbids those younger than 18 from possessing long rifles if, 1, their rifle is too short, or 2, if they are under the age of 16, or 3, they are not in compliance with the law that requires a hunting certificate. Clearly, Kyle met the first 2 provisions. The problem was, did he meet provision number 3? That is, being in compliance with the law that requires a hunting certificate. Mark Richards said, yes, he is, because he wasn't hunting. Binger fired back and said it doesn't matter if he's hunting or not, he still has to have the certificate. Later, Kyle's defense team revised their interpretation of 948.60. They basically said that Wisconsin law forbids those younger than 18 from possessing long rifles if, 1, their rifle is too short, or 2, if they are under the age of 16 and they are not in compliance with the law that requires a hunting certificate. Because Kyle was not under the age of 16, he met provision 2 outright, regardless of whether he had a hunting certificate or not. If you'll notice, the length of the rifle barrel doesn't affect any of this, and everybody knew that the rifle was long enough. The length of the rifle barrel was never an issue. It was never the deciding factor on whether count 6 should be dropped. Instead, the issue was which of these interpretations is correct. Judge Schroeder threw up his hands and said, I have no idea, basically. And based on the rule of lenity, which basically says that if the state legislature can't draft clear laws, then the tie goes to the accused. And since then, anti-Kyles have cried that the wording of 948.60 does not reflect the will of the people. So they set to work drafting new legislation to close that loophole and show the world what Wisconsin truly meant when it tried to ban possession of rifles by those under the age of 18. So what happened? We can simplify the amended sub-statutes in the following manner. 948.602A now reads, Wisconsin law forbids those younger than 18 from possessing a dangerous weapon unless, and this is now an exception, not a provision, the person is legally hunting and the person is at least 16 and has a certificate of accomplishment. Then they added this subsection 2D that says, Wisconsin law forbids those younger than 18 from possessing a dangerous weapon regardless of any other exemptions if the person is using a short-barreled rifle. And I am not sure why they had to add this as a separate subsection. It seems like if they would have just added another phrase on the end of the 2A that basically says, and is using a long-barreled rifle, that would have taken care of it. I don't know what they're doing, but whatever. Maybe there's a reason why they felt that they had to do it this way. If you can come up with one, let me know. Okay, so what became of Assembly Bill 817? Now remember, the existing law was incorrect. It did not reflect the will of the people. It's not what the legislature intended. And so Assembly Bill 817 is going to change that. It's going to come up with the law as the legislature wanted it all along. So again, we're going to pass this Assembly Bill to show the world what the true meaning of 948.60 was all along, but just wrongly worded. Well, it failed. It was defeated. So, what is the will of the people? Well, according to what we see here, it was the existing 948.60 all along. So evidently, Kyle didn't get away with the technicality at all. Not a loophole. Kyle's possession of the rifle that night was, in fact, justified. Like my video and subscribe to my channel. Oh, and one more thing. I have linked the Assembly Bill in the description below if you want to read the actual text.